Evening. Can you hear me?
Good evening. Yes, we can.
Okay. Can you see the PowerPoint presentation?
Yes.
Okay. All right. Good. Okay. Because we're having some issues. Let me just confirm to Miguel that I'm in. Okay. All right. We're going to start in a few seconds. Okay. Okay, good evening, everyone. Last week we looked at module 5. We looked at the mortgagor's duties, liabilities, and rights, and we said that it was difficult to talk about the mortgagor's duties, liabilities, and rights without mentioning the mortgagee's duties, liabilities, and rights. But we attempted to try to do so in any event. Tonight, we're going to look at the mortgagees, that is the lenders, duties, liabilities, and rights. But before we do, I think we had some what they call parking lot issues from last week, which I promised to get back to you on. So let me deal with those. Okay. So the first parking lot issue was the exam format. Okay. Let me try to get my PowerPoint presentation. Takes a little while to get moving. For some reason. Okay. Okay, there we go. All right. So, like I said, the first parking lot issue is the exam format. The modules that I will be going through with you are 5, 6, 7, 10, 11, and 12. And the ones that Mrs. Archer will be going through with you are 1, 2, 3, 4, 8, and 9. And this will be my second session with you guys. Ms. Archer comes back on next week, and then I won't see you guys again until the first part of December. I think December the 1st. So she'll do the next 2 sessions, and then I'll end up with the last 3. But the format of the exam is going to be this: be guided by Ms. Archer's instructions on the modules that she is taking you through. That's I think there'll be essay questions or short answers or something like that. So that's for modules 1, 2, 3, 4, 8, and 9. And the format of my questions for the modules that I cover will be 2 sections. The first will be true and false, and the second will be multiple choice. So there'll be 3 sections in the final exam: 1 true and false, 1 multiple choice, and 1 essay. The first 2, again, just to reemphasize, the first 2, true and false and multiple choice, will cover the modules that I will be taking you through, and the essay or short answers will be the modules that Ms. Archer is taking you through. Okay. What I will be doing is I will send you some some questions from a question bank on each of the chapters. So look forward to probably tomorrow to receiving some questions on the units that you had covered with me so far. So there'll definitely be modules 5 and 6. I'll try to begin 7 tonight. Okay. So are there any questions before we move to the next part?
Sorry, you can repeat that, please? The ending part?
I said that probably tomorrow, probably by tomorrow, I'll be sending you some questions. So from a question bank of questions. So you can look forward to receiving those tomorrow. And I said that I would, I'm going to try to start chapter 7 because we missed one session and we're trying to keep it on schedule. So I'm going to try to commence module 7 tonight. And what we don't finish tonight, we will finish on December the 1st when I see you again, because I'll have two more sessions with you guys. Okay. So, so any questions on the exam format before I go forward to the next parking lot issue? Okay, no
Ms.
questions?
Archer had said she was going to send us some questions also, but we never received it. Will you be
Okay.
able to follow up on that?
Well, what you probably need to follow up with Mr. Pratt, Miguel. Because I don't actually, she know I actually are employed by the institute. We are contracted as adjunct lecturers. So Miguel would you have to coordinate that with Miguel Pratt.
Okay, thank you.
Right. So okay, if there are no other questions, let's move on to the remaining 3. I think there were 4 parking lot issues. Okay. The question was asked, were any subsequent amendments to the Homeowners Protection Act 2017? No, there are none, but I understand that the government is looking at it. Now, how advanced they are in looking at possibly doing some amendments, I don't know. But currently there are no amendments to the Homeowners Protection Act 2017. Okay. The next question related to what are the consequences of not giving notice of transfer of the mortgage by the mortgagee? And the answer to that is that Section 20 outlines statutory offenses and fines for contravening any section of the Homeowners Protection Act. And Section 21 outlines administrative offenses and penalties which may also be levied for contravening any section of the Homeowners Protection Act. And we're going to look at that in the last segment of this session with you. Okay, so we'll come across this again. But just to show you what those statutory offenses and fines are, well, the fines, how they are lined up, and also the administrative offenses. Let me just go to the next screen. So the statutory offenses and penalties in Section 20, it states basically that a financial institution that contravenes or fails to comply with any provision of this act commits an offense and is liable to pay a fine not exceeding $200,000. So the fines are steep. Also, a director of a company who knowingly concurs in a contravention or failure to comply with any of the provisions of the act commits an offense and is liable to pay a fine not exceeding $100,000. Okay, and that's the statutory offenses. Now, on the administrative side, fines by the regulatory body from section 21, notwithstanding any penalties that may be imposed under section 20. A financial institution that contravenes or fails to comply with any provision of this act may be subject to an administrative fine not exceeding $200,000. And a director of a company who knowingly concurs in a failure to comply with any of the provisions of the act may be subject to an administrative fine not exceeding $100,000. So if we look at those two penalty clauses, sections 20 and 21, a financial institution can be fined up to $400,000, and a director can be fined up to $200,000 collectively when you combine the two sections, the sections 20 and 21. Okay, but just note that with regards to the administrative fines, it says that they may be subject to, whereas in the statutory, it says that they will be fined. Okay, so just note those two differences. Okay. Let's now go to our text for module 6. Are there any questions on? Oh no, sorry. We still have one more question, eh? Number 4. Yes. Question number 4. The question was asked, what is the meaning of save any surplus amounts referred to in subsection 7? The exercise of the power of sale shall discharge the mortgagor from any and all liabilities for any sums due under the mortgage if at the date of sale, and this is where the question arose from subsection A, a sum equal to 1/2 of the principal and accrued interest has been paid to the mortgagee. And so the explanation to that is a sum equal to 1/2 of the principal and accrued interest has been paid to the mortgagee. Let me just give you an example. Okay. Let's assume that there's a mortgage loan where these amounts are a little out of whack. They don't line up. But the principal loan balance outstanding as of the date of sale is $80,000. The accrued interest is $80,000. There are late fees of accrued interest of $10,000, late fees of $1,000. So that gives you a total payoff as of the date of sale of $91,000. And in this case scenario, the sale proceeds $45,000. So the mortgaged property was sold, $45,000 was collected and applied to the mortgage loan, which left a residual principal balance of $35,000, accrued interest of $10,000, late fees of $1,000, and then the total residual balance outstanding was $46,000. Noting that in the above example, the sale proceeds are exactly 50% of the loan principal balance and accrued interest. That is $80,000 plus $10,000 accrued interest gives us $90,000. And when we divide that by 2, we get $45,000. So it says to a sum equal to at least 1/2 of the principal and accrued interest. And so that is, of course, we know in most circumstances, the bank or the financial institution will apply the sums, first of all, to the principal and then accrued interest and late fees. In this instance, we are assuming that there's no real property tax outstanding. Because as you may know, or as we will see later on in this presentation, that real property tax ranks ahead. So real property tax, it is assumed, is either to be paid or not applicable in this circumstance. Okay. And again, I apologize for those figures being a little off in the actual slide, but the sale proceeds is 45 and the residual balance, so 45 from the 80 gives us 35, and that's how we end up with our residual total balance of 46 after we applied the $45,000 sale proceeds. Okay, any questions on that before we move on? Okay. Let me just state here with regard to the questions, the true and false questions and the multiple choice questions. The actual cases, you don't have to be concerned about the actual cases and knowing the names of the cases. However, you would be expected to know, stuff such as the Homeowners Protection Act 2017. But the actual cases, like the one that's appearing on your screen, the ones Foley and Hill and Joachim and Swiss Bank Corporation, you won't need to to know those. But you'll be able to see the type of questions when I send the sample questions from the question bank for the true and false and for the multiple choice questions. Okay, so just a lay fares, because I know that there's a lot of stuff in this manual. But what you will also see is that a lot of the stuff is you refer to a lot of the same things periodically, that they're interrelated. So the repetition is good in terms of having to refer back to certain statutes and different applications of the law to mortgages. Okay, so let's look, you can follow with me in your manual. So we begin module 6 in earnest. And I'm not going to go through every detail, but I'm going to try to be as comprehensive as possible. Okay, so let us first look at the banker-customer relationship, because that forms the basis with on the deposit side as well as on the lending side. Okay, so I'm going to go through that fairly quickly, but I will pause on those areas that relate specifically to mortgages or to lending. So under the common law, the banker-customer relationship is contractual. It is one of debtor and creditor, and debtor because on the deposit side, because the customer's deposit is a debt that the bank owes to the client. So so on the deposit side is debtor and creditor, and then of course we see that position reversed when it comes to mortgages or loans, and so it becomes one of creditor debtor. Also, the banker-customer relationship has certain express and implied terms, and the case there, if you wish, a lot of these cases you can read up in your spare time. There are some summaries that are available on the internet, so you can read them up, or if you have access to some banking law books, You can look them up. If you have any difficulty, shoot me an email, and I will try to get any of the summaries to you. But Foley and Hill and this Joachim and Swiss Bank are two of um, the more, for want of a better word, the more popular ones, because they form the basis of the banker-customer relationship. Okay, so you'll hear about these two cases often. Okay, the general duties of the bank. So the general duties of the bank are to carry out its customers' instructions promptly and without exceeding its authority in obeying the mandate established at the commencement of the banker-customer relationship. The bank must also discharge its contractual duties with requisite skill, diligence, and standard of care. And again, we see Jurgensen, Swiss Bank, 1921 case popping up again. Okay. The bank also has a duty of care in tort, particularly for any negligent misstatement. And some of these things we're going to go over, and I'm going to give you some, in some of these I'm going to give some definitions or explanations. So stand by. So another general duty is that the bank has a duty of care in tort, particularly for any negligent misstatement that it may make in providing investment or any other advice to its customers in the course of discharging its contractual and tortuous duties concurrently. Okay, so you have to be careful that when you are giving advice to the client, that you are not making any misstatement. And we're going to look at that a little bit closer in a few minutes, and also in later on. There's also a fiduciary relationship, based upon loyalty, confidence, and trust, upon which certain liabilities may extend for breach of both fiduciary and equitable duties owed to the customer. And there's a case there of Woods and Martin, 1959. Okay, so let's look at some definitions. First of all, tort, and then we'll look at fiduciary. Okay, so first of all, tort. In common law jurisdictions, tort is a civil wrong that unfairly causes someone else to suffer loss or harm, resulting in legal liability for the person who commits the tortious act, called a tortfeasor. Okay. These sections that you'll see popping up that are in yellow or peach or whatever it is on your screen, these are not in your book. These are ad libs that I've done in terms of definitions, okay, and etc. Generally speaking, a tort is when one person or entity inflicts an injury upon another in which the injured party can sue for damages. In tort lawsuits, the injured party, referred to as the plaintiff in civil cases, comparable to the prosecutor in a criminal case, seeks compensation through the representation of a lawyer, a personal injury lawyer, from the defendant for damages incurred, that is, harm to property, health, or well-being. And there are 4 elements of tort. Okay. The 4 elements to every successful tort are duty, breach of duty, causation, and injury. So for a tort to be well-founded, there must have been a breach of duty made by the defendant against the plaintiff, which resulted in an injury. And there are 3 main types of tort. Okay, there are intentional torts, negligence torts, and strict liability or absolute liability torts. And examples of these, I'm going to go through on the next few screens. So let's start with intentional. Examples of intentional torts. Okay. Um, examples of intentional torts are assault, battery, false imprisonment, fraud or deceit, trespass to land and property, and defamation. So those are examples of intentional torts. Now we move to examples of negligence torts. This is the slip and fall accidents, automobile accidents, pedestrian accidents, bicycle accidents, and medical malpractice. And then finally, the absolute liability torts or the strict liability torts. These involve defective products, animal attacks, and abnormally dangerous activities. Okay, so that takes care of torts. Let's look now at fiduciary. A fiduciary is a person who holds a legal or ethical relationship of trust with one or more other parties, that is, a person or group of persons. Typically, a fiduciary prudently takes care of money or other assets for another person. Okay, so that basically explains a fiduciary. Okay, so let's go back to our text and let's look at the general duties of the bank. So the bank owes a duty of confidentiality to the customer, whereby it may not disclose the customer's banking and personal information to a third party, unless one or more of the following exceptions apply. The first one is disclosure under compulsion of law. The second, disclosure in the public's interest, disclosure in the bank's interest, and disclosure with the customer's express or implied consent. Okay, and the case for that is Tonier versus National, Provincial, and Union Bank of England. Again, that is a key, one of those key cases, those base cases, right? So the bank is also required to provide a statement of account to the customer periodically and upon request, although the customer is not obliged to check the bank statement for errors or omissions. The bank must exercise proper skill and care in carrying out the customer's instructions, which is not only a standard of service, but a recognized duty in law. Okay. Any questions on those before we move from general duties to general rights? Okay, general rights. Let's look at the general rights. Okay. Okay, there are 7 of these general rights that we have listed in the manual. And the first is to charge the customer a reasonable commission for services rendered and interest on overdrafts and on loans. To demand repayment of any loan or borrowing, for example, an overdraft, made to the customer on current account. Thirdly, to exercise a lien over any customer securities deposited other than items held in safe custody with regard to any customer debt or borrowing. Fourth, to be indemnified by the customer for any expenses or liabilities incurred while acting for the customer as his agent. Fifth, to return unpaid any customer check where there are insufficient funds to cover the check, and the same would result in an unauthorized overdraft. So, except for the case of an authorized overdraft, where an overdraft has been actually granted to the client, if a check comes in which will overdraw the account, the bank has the right to return the check. 6, to exercise the right of set off, which is the right under certain circumstances to take a credit balance on one account and set it off against a debit balance in another account owned by the customer in the same right. Okay, so care must be given. So if customer A has let's say they have a deposit account in their own name, and they have an account, deposit account in the name of their name A, and also B, which is not an and or account, but is an and account. You cannot take from that and account. But if it's an and or account, you should be able to take from that and or account. Okay. And then 7, to combine accounts. Sorry. Okay. So the duties and rights of a bank must be recognized and discharged in the context of the duties and rights of the customer in order to maintain a sound contractual and fiduciary relationship between the bank and the customer, and to minimize and mitigate any breach of contract of the banker-customer relationship or the contract. Okay, and one such relationship is the mortgage loan, and also an overdraft facility that is formally established. Okay, so those are the general rights. Now let's look at the duties of a customer. Okay, the duties, rights of a customer. So let's start with the duties. The duties of your customers are to pay reasonable charges for services rendered, to issue checks only if sufficient funds are available on the account or an agreed overdraft facility is in place and has not been fully utilized. 3, to exercise reasonable care in drawing checks to avoid fraud or forgery or to mislead the bank. 4th, to advise the bank of any known forgeries. So those are the duties of a customer. Okay. The rights of a customer. The right to repayment of funds deposited on demand. So if they have deposited any funds, they can make a demand for those funds. Secondly, the customer has the right to have the bank discharge its duties to him or her or to them. And thirdly, the right to have funds deposited appropriated to a specified account to cover checks he wants to pay. If the customer does not allocate where the payment into account or credit is to be made, then you, the bank, can appropriate at your discretion. And normally, if you know your customer fairly well, you know that and the customer has more than one deposit account, you pretty much know which account the customer would probably want the funds to go to. But when in doubt, again, you can make that decision at your discretion. Okay, so those are the duties and rights of the bank, and the duties and rights of the customer. So as we're talking about specifically about mortgages in this course, let's look at the specific rights of the banker's mortgagee. And these are not inclusive. And some of them you've come across before in previous modules. But notwithstanding that, we'll go through them. You'll go through them here, excuse me. Okay, so there are 8 of them, and here they are: the right to possession, the right to statutory and contractual power of sale, the right to additional property, the right to documents of title, the right to protect the property mortgaged to them, the right to tack, that is to add on any further monies advanced, the right to appoint a receiver, and the right to consolidate any debts. So let's first of all look at the right to possession. Okay. The legal mortgagee is entitled to possession of property as soon as security over the property has been executed, and even though there has not been any default on the mortgage loan or any other breach of contract, okay, of the mortgage contract, okay. I notice it's saying that they are entitled to possession, okay. It's so sometimes an entitlement does not necessarily mean that you will move or you ought to move. So it's similar to let me give an example. Let's say that in your financial institution, you may be entitled to loans at concessionary staff rates, or you may be entitled to, say, 2 or 3 weeks vacation. Okay, there are certain stipulations that must be met in order for you to actually exercise those entitlements. Okay, so in the case of you getting a loan from your financial institution at staff concessionary rates, sometimes you have to be there a certain length of time, and then of course there's some qualifications, other qualifications you have to meet. With regards to entitlement to vacation, there's a certain, sometimes there's certain time frames that are blocked off that you cannot take, and so you have to wait until the vacation block is opened up, and then you can take your vacation within that time. Okay, so being entitled to something does not mean that you can immediately benefit from those entitlements. Certain things have to be in place. So while the mortgagee lenders are entitled to possession, certain things have to be in place. And we've talked about some of them last week, and I think you may have discussed some of them previously with Ms. Archer. And of course, again, we will be looking at some later on tonight. Also, it says here, a court order is required to enter into possession if the mortgagor is in occupation of the property, and in some cases where the mortgagor refuses to leave or refusal to leave is anticipated, an eviction order is also required. The costs of entering into possession are borne by the mortgagee, by you, the lender. Okay. So you see in yellow there, I have the or refusal to leave is anticipated. So for example, before this client would have breached some portion of the mortgage agreement. In most cases, it relates to going into default related to payment. And so you would have had some exchanges with those customers, or at least you would have some documented cases of where you've communicated with that customer, and you would be able to tell if the customer is a difficult customer, if they've been problematic and they'll probably cause problems. So if you anticipate that the client might refuse to leave willingly at the time that you make your request to the court to enter into possession, you may also want to get an eviction order for vacant possession as well. Okay, that doesn't necessarily mean that the client will still go willingly. You know, you may have to now, get a court-assisted bailiff to go with you and actually have the people forcibly evicted. Okay. So the bank has a discretion to adjourn the proceedings for possession of mortgage property, particularly in the exercise of their power of sale under the terms of the mortgage, where there appears to be some likelihood that the mortgagor may be able to pay any sums or the whole of the sums which may be due and owing on the mortgage, or they may also be able to remedy any default within a reasonable time. So those are three instances where they may be able to pay any sums or pay the whole sums which are due and owing, or they may be able to remedy if there's some other default upon which you are exercising your right of possession. Okay. The right to statutory and contractual power of sale is one of the most common of the mortgagee's remedies. Okay. It is designed to recover the whole sum owed, although that is not always realized. And also any surplus of the proceeds, as we will see that you are a trustee to ensure that those funds, any surplus goes to the mortgagor. On the flip side, if there's a shortfall, you, the mortgagee, may sue the mortgagor on the personal covenant to repay. Okay. And we'll look at where you may be barred or exceptions to being able to sue them. Excuse me. The mortgage will contain either an express power of sale, but if it doesn't, it certainly will have an implied power of sale contained in the document. But for the most part, I am aware that most financial institutions, the power of sale is an expressed contractual right. And even again, if that fails, there is a statutory right that you, the mortgagor, have to exercise the power of sale. Although the statutory power of sale arises when the mortgage money becomes due, it cannot be exercised until one of the following conditions has been met. Okay, and so remember we said that there was an entitlement. Here is one of those entitlements. The statutory power of clause, power of sale clause is an entitlement, but again, certain conditions have to be in place or met. The first of which is the demand for payment followed by the default, continuing for 3 months, or interest remaining in arrears for 2 months, or breach of some covenant other than the payment of principal and interest. Very rarely do you see banks exercising that third option, breach for some other covenant, but they are. It is there if the mortgagor breaches some other covenant contained in the mortgage document. You have the the entitlement or the right to exercise your power of sale. Since the mortgage of the land includes fixtures and anything subsequently affixed to the mortgage property after the security has been executed, the legal mortgage is entitled to the additional chattel, example, furniture, etc., and fixtures. Very seldom, though, do you find that banks rely on furniture. And so what will end up happening is they would encourage the mortgagor to remove the furniture. And so a letter will be sent out asking them to remove the furniture, failing which the bank will take action to dispose of the okay. So so if the mortgagor doesn't remove it, the bank will remove it. Oftentimes, the furniture that is left behind is has very residual value. Okay, it's broken or whatever it is. Okay, but fixtures would certainly include things like what do you call these things? These split split air conditioning units, things like water tanks, where there's a well water system. So that is a fixture. Okay, and even more so if the property is not connected to the public water supply. Okay, so those are some things that will be deemed as fixtures to a mortgaged property building. Okay. So the fourth is the right to documents of title. The first legal mortgagee is entitled to all the title documents or deeds, though the mortgagor may inspect and make copies of them at his or her or their own expense. An equitable mortgagee is not entitled to the title documents or security documents unless this is stipulated in the equitable mortgage agreement. In instances where a second mortgagee has pari passu rights, that is cut from a Latin term that means on equal footing, it may insist on holding certified copies of title documents. And this would be at the cost, the cost would be at the expense of usually of the mortgagor. Okay, so sometimes you may have Bank A who take out a mortgage, and for some reason the client goes to another financial institution and they have sufficient equity in the mortgage, and rather than taking out the second mortgage with lender A, they go to lender B. And then sometimes you may be approached by lender B for a pari passu second mortgage, where their rights are on equal footing. So if there's a default by the client, their ranking in terms of, so for example, after real property tax has been cleared, Bank B will also have the same rights to the sale proceeds as Bank A. So they would share them in equal amounts. Often you'll find that unless there is substantial equity, Bank A will decline those rights. Decline that request from Bank B to have pari passu rights. Okay. In my there was at least one financial institution that I worked with where actually two. There are two financial institutions I worked with where we were approached by another financial institution for their mortgage, their second mortgage, to be to have pari passu rights. And in one of those instances, we declined. It was a civilian, a case of a civilian, an individual who had approached us, and so we declined to have Bank B ranked the same as ours, because we had the first right. Okay. In the other instance, the pari passu was granted. This is in the case of government, where the government came to our bank to borrow, and they came to another, and they went to another bank, and this was a joint agreement. And so this happens very frequently in government borrowings, where the government spreads well, I should say the government, where financial institutions prefer the risk to be spread. So if a government wants to borrow $50 million and they come to local banks, you may find one bank say, I'm only prepared to do 25. You need to find another bank that'll do the other 25. Okay. And in that instance, you will find that Bank A would grant the government pari passu rights to Bank B. Okay. So the fifth one, or E, the right to protect the property. So most mortgages contain terms regarding the borrower's obligation to maintain and insure the mortgage property. However, the mortgagee has a statutory and common law duty power to prevent deliberate damage, and also to carry out any necessary repairs, and also to insure against fire. Also in our jurisdiction, you should insist on also for hurricane. Okay, that is a huge a huge risk that needs to be insured against, and it is one which really causes the premiums to go up. So so normally a person who insures their house, they may insure it against fire, but they may not insure it against hurricane damage, and they can significantly pay less annual premiums on their homeowners insurance by excluding paying for hurricane. So hurricane by far is the most major concern, I should say, of the mortgagee, of us lenders. Okay, so we would include in there to insure against fire and also hurricane. If the mortgagee goes into possession of a mortgage property to carry out repairs, it must account strictly for any work done. For example, the appointment of a receiver may be recommended in this instance. Okay, for more than one reason, because the bank may not have the necessary manpower or experience to do it, and two, because of the liability risks involved. Okay, so in that instance, the bank, the lender, may appoint a receiver. Additionally, the right to insure against fire is only to the extent of 2/3 of the reinstatement value, and does not cover other risks. So, as I said, we attach here in the Bahamas the extra onus on the client to ensure that hurricane is covered, and also that the full value of the property is also covered, in order to avoid the risk of finding ourselves in the case of a fire, only covered by 2/3. Okay, so so there may be some specific conditions either in the commitment letter to the client, and we'll talk a little bit about the commitment letter when we look at the lending process, or some people call it the facility letter or the commitment letter. So it may be contained there, or some financial institutions actually have it embedded in the mortgage document itself. Okay. So another, a 6 or the F right. So there's the right to tack to add further monies that the bank may have advanced or may advance. So the mortgagee, as a secured lender, has the right to add further money to the security so that the money is also secured. The mortgage document normally has terms to provide that the mortgage secures any further advances. Okay, so if you read through a mortgage document, you'll see something, which is pretty much legalese, but you can tell from the wording that, it says basically that any future sums or monies advanced. Okay, so it'll be kind of worded very legalese, but you should be able to pinpoint the actual clause that gives you the right as the lender to use that mortgage document to cover any other debts that you may advance to the client. So it could be an overdraft, it could be a credit card, it may be a credit line. Okay. G, the right to appoint a receiver. A mortgagee may appoint a receiver under the terms of the mortgage to collect rents from tenants on behalf of the mortgagor as his agent. Okay. Again, this is particularly where it's a commercial property or a property, an income-producing property. Okay. The receiver's costs will be a debt to the mortgagor, and the terms of the appointment of the receiver may exclude a bank's liability for monies it does not receive. Okay, so there'll be a clause in there outlining the banks that it excluding the bank's liability for monies it does not receive from the receiver. Okay.
Question?
Although there is recourse to the receiver. Okay. And the bank can exercise those. Generally, you'll find that receivers are pretty much reliable, and they will forward funds that they receive from tenants to the bank. Okay.
Question?
Sure, go ahead.
The appointment of the receiver must be done by means of a legal document, legal contract that the mortgagor will be privy to?
I'm not sure if the mortgagor will be necessarily has to be privy to it. I can find out if that is the case, but the receiver is legally appointed. Okay, the receiver is legally appointed, and the mortgagor should be advised. But I'll make that a parking lot issue, and I will confirm whether they must be advised and if that advice must be in writing. Okay. So let's look further at the right to appoint a receiver. Okay. It is very specific for tenanted properties where there is income. It is exercisable in the same way as the power of sale. And it is used because the mortgagee might decide that instead of selling the property, they want to keep the income that is generated or that is guaranteed, or they feel that is guaranteed from the property. So for example, let's say this is a property that may be leased to the Bahamas government, and those sums are consistent. You may want to keep that going, particularly if there's still enough time left in the lease agreement that you would generate sufficient income from the remaining time or less of that lease agreement to completely pay off the mortgage loan. Okay, and then of course it is used for tenanted properties because the receiver administers the property, that is, collects rents, pays the mortgage, etc. Okay. And then finally, the right to consolidate. The bank may consolidate mortgages, although banks take what they call all monies mortgages. They have an all monies clause in mortgages, which eliminates the need for separate mortgages. Now, some mortgages don't have it, but up to the time that I was actively in the front line of the lending industry, you found that financial institutions had these all monies clauses, and they also had revolving type credit clauses as well. Okay, so there's all monies clause and revolving credit type clauses in their mortgage documents. So an all monies clause lets the lender use the home as security against any or other debts that a person may have with that lender. So, for example, the lender may come to you and establish a mortgage loan account, and then subsequently they may apply to you for a credit card, and that document may also cover, because of the all monies clause, would cover the credit card. Okay. Now, like I said, there were some specific rights of the mortgagee. We looked at a lot of these. Some of them you've come across before, and that is the enter into possession, the point of receiver, which we've covered in here, the statutory power of sale. So at least about three of these, probably even four, because we talked a little bit about the for shortfall, that you can sue. You can sue on the covenant to repay. And so I think foreclosure may not have been specifically mentioned here in this. And like I said, sue on the covenant to repay may have been indirectly included in here. But I know that you would have covered the mortgagor's remedies in module 5, I think it is, or module 4. Anyway, in one of the, module 4 or one of the previous modules with Mrs. Archer. But right now, what I'm going to do, and of course, again, you may want to take notes, but then again, this PowerPoint presentation will be sent to you, so you'll be able to so don't spend too much time trying to take this down. But what I've done is I've developed a mnemonic, okay, and it comes from it's derived from the Greek, which means to remember, okay, and here it is. I call it SAFES, SAFES, okay, to help you to remember some of the remedies, or to remember the remedies of a mortgagor. So there's sale, so there's the power of sale by the mortgagee, but also sometimes banks would allow the mortgagor to sell as well. And the power of sale can either be done by public tender or auction. And usually by tender, it is covered under standard mortgages. Public auction is usually under guaranteed mortgages or some commercial mortgages, and particularly where a receiver is appointed. And so the receiver may sell by auction. So you have the first sale, A, appoint a receiver, F, foreclosure, E, enter into possession, and S, sue on the covenant to repay. Okay, and then there's a note there that there is currently no no allowance to stop interest from continuing to accrue on a mortgage debt throughout any of the above processes. The possible exception may be only where there's interest only outstanding. So when where the principal sum has been extinguished, obviously there's no more accruing of interest because there's no more principal. But as far as there is now, there's currently no allowance to stop interest from continuing to accrue on a mortgage debt. Okay, where there's a principal residual balance. All right. So let's look at some specific duties of the bank as mortgagee, and three of them we'll be looking at: investment advice, again looking at the exercise of power of sale, and also looking at real property tax. Okay. So the first one is investment advice. With regard to lending, and generally when a bank gives investment and or lending advice, it owes a contractual duty and a tortious duty to take reasonable care in the provision of such advice, and must not do so negligently or recklessly. Okay. The duty to take reasonable care in providing advice is more pronounced in instances where the banker advertently and personally assumes responsibility of giving and or volunteering investment advice, and the customer relies upon such advice. Thirdly, must be noted, however, where the ordinary business of the bank does not involve providing advice on the viability or prudence of residential or commercial projects for which it is lending money to the customer must make it clear that the customer is seeking the bank's advice and not just simply applying for a loan, in order for the bank to be under a duty of care to that customer, that borrower, and hence liable for negligent advice. Okay, so where in ordinary business the bank does not give that type of fiduciary advice, the customer, in order for them to be liable, the customer must make it clear that they're seeking the bank's advice as such. Notwithstanding the above, banks or lenders must be prudent and aware that in merely providing information to the customer, it is still under a duty of care to ensure that the information provided is accurate. Okay, and they don't be talking about negligent, we'll be talking about negligence. Okay, so we're notwithstanding the above, The bank must be prudent and aware that in merely providing information to the customer, it is still under a duty of care to ensure that the information provided is accurate. This legal principle is particularly important since statements made by bank officers who have actual or apparent authority to make such statements in the ordinary course of the bank's services without any effective disclaimer, and upon which a customer may reasonably be expected to rely upon, will attract legal liability to the bank if such statements are made without reasonable care. And such instances are bank references and investment advice. Okay. I recall when I worked at, and I'll give the name of the bank at this time. I worked at Fidelity Bank, but I worked on the commercial bank side. Okay. At the time, Fidelity also had the investment side. Okay. And Fidelity at the time was when they were giving loans, also offering financial planning advice, okay, and investment advice. But in doing so, the lenders, initially the lenders were not allowed to provide such investment advice or financial planning advice, okay? So they had to make an appointment with one of the officers on the investment bank side to meet with that client in order to give that advice, okay? And I think, I believe that eventually it morphed where some investment or financial planning advice was also vested in some of the lenders to some degree in that particular financial institution. Okay, but again, you know, I am sure that, you know, they were comfortable that the persons were trained and qualified to give that type of advice, and any advice outside of what they were trained to give would then they would have to refer it either upward or outward. Okay, so this is a very important legal principle. Who have actual or apparent authority to make statements in the ordinary course of offering services without any effective disclaimer, that they can attract legal liability to the financial institution. Alrighty. Established recent decisions have held that the bank, and I put recent in brackets there, because you know you're looking at a period of 10, 12 years. Okay, some of these legal opinions which have been established go back prior to the 1990s. Okay, so that is why I put recent in brackets. So established recent decisions have held that a bank may also be liable for contributory negligence in lending cases to other professionals. For example, where appraisers and attorneys are involved, whose advice has supported lending which caused some sort of loss to the mortgagee. Point number 2, the exercise of the power of sale. The mortgagee has a limited or equitable duty to the mortgagor and any guarantor to take reasonable care to obtain the true market value of the property and the date on which it decides to sell the mortgage property. We've come across this before. Okay, again, it is all interrelated, and the repetition does help. However, the mortgagee does not have a duty to take any action to preserve the value of the security ahead of obtaining possession and control of the mortgaged property. The mortgagee has a duty to account for the proceeds of the sale of the mortgaged property, since it is a trustee for the proceeds for the beneficial interest of the mortgagor. Okay, so there's a trustee obligation that comes into play there. So those are the three specific duties of the banker's mortgagee with regard to exercising the power of sale. And now, thirdly, with real property tax. Okay. Outstanding real property taxes represent a first charge over mortgaged property, as per Section 21 of the Real Property Tax Act. And additionally, under Section 7, subsection 5 of that act, real property taxes can be assessed for up to 10 years retroactively. More importantly, the Fiscal Reform and Tax Relief Act 1990 amended the original Section 16 of the Real Property Tax Act by the inclusion of sections which relate directly to the legal obligation or obligations and the liability, and the liabilities of mortgagees of mortgage properties. And we can look at those. We can look at those right now. Okay. So, on a strict interpretation of the aforesaid sections, that is section, the amended section 16. Okay, so we see section 16A, subsection 1 and subsection 2. It appears that the mortgagee is deemed to be the owner of the mortgaged property, and as a result is liable to pay any outstanding real property tax amounts. Okay, such liability or legal obligation should not of itself deter or delay the sale of the property, as the prospective purchaser may agree to accept liability for the payment of the outstanding real property taxes. Of course, there's going to be some formalized legal documentation where there's some indemnity to indemnify the financial institution if that latter cause of action is taken, where they allow the prospective purchaser to accept the liability. However, my recommendation would be to pay those sums up front. Okay, notwithstanding any legal document indemnifying you by the proposed or the prospective purchaser. Okay, so again, my personal recommendation would be, and I think your attorney who's acting for you would ensure that those funds are taken out, because they need to ensure that the real property taxes are paid or will be paid, because they have also given you, they've expressed an opinion of good title to you. Okay, or they would have expressed it to the purchaser, and they could be on the hook for that. Okay, so again, like I said, I would take those monies up front when exercising it, the power of sale. Okay. If you, I don't have the page number, but the relative sections 16A, subsection 1 and subsection 2 are in your module 6. Okay, and I'll just quote it here. It says, where property is mortgaged under deed of mortgage executed either before or after the coming into operation of this section, the mortgagee of the property shall obtain from the chief valuation officer a statement as to the amount of tax or surcharge relating thereto, due and payable under the act in respect of the property. In any case where tax remains unpaid in respect thereof, the mortgagee is deemed also to be the owner of the property for the purposes of the provision of this act, relating to the payment and recovery of tax by and from any owner of property. And then I'll just read the first portion of subsection 2, which says, where a mortgagee is deemed to be the owner of the property under subsection 1, the mortgagee shall, in accordance with provisions of section 18, pay or cause to be paid the amount of tax or surcharge, as the case may be, due and payable under the provisions of this act in respect of the property. Okay, but it goes on with some other stuff. But you as the mortgagee, you as the lender, you are considered the owner according to section 16A, subsection 1, and under subsection 2, the government is looking to you for payment of any outstanding or any unpaid portions of real property tax. Okay. Any questions on that before we look at liabilities of the banker's mortgagee? Okay. So again, earlier I alluded to talking about negligence and also misrepresentation in giving advice. Okay, but let's look at the first one first, undue influence. Then we'll look at the mistake, and then we'll look at liabilities by looking at misrepresentation and negligence. So first of all, undue influence. Okay, undue influence is an equitable principle where contracts, for example, mortgages, or gifts which are made or given on the premise that one party has obtained a benefit by reason of the exercise of influence over another person, which is manifestly disadvantageous to the other person. Okay. In those instances, they will be set aside and considered void or voidable. Undue influence is normally based upon and carried out in the context of a special relationship where trust and confidence exists, or a familial or romantic obligation may underscore the relationship, such as a doctor and patient relationship, attorney and client, husband and wife, parent and child, or a banker and customer. Banks should be particularly aware of the concept of undue influence as a third party, spouse, parent, or child may grant a guarantee or other security to the bank over the family home to support the borrowing of the contracted party of a primary borrower of the bank. Just to kind of explain that to some extent, sometimes we have instances where a person may come to the bank to borrow, but they don't have the necessary collateral or down payment, and so another party may own a property. It could be a house. It could be an undeveloped property. Okay, that person may be a spouse to the borrower, the prospective borrower. It might be a parent. Okay, it may be a child of the borrower. Okay, and so they will come and they will say, well, I have this property. I want to pledge this as security, either by way of surety or as guarantee. And we'll probably talk about that generally in a little bit for the borrowing. Okay, so what needs to happen is that I'm kind of jumping a little ahead of myself because I'm talking where I will talk a little bit about getting independent legal advice. But let me just kind of not jump the gun, but just set that stage. So you may have someone who doesn't have sufficient equity or down payment or contribution for a mortgage loan, and someone else steps in, okay, and they will pledge their property to satisfy the requirements of the bank, okay, and that person could be a spouse, that person could be a parent of the borrower or a child of the borrower. And as I mentioned earlier, they may do it either as surety or they may do it as guarantor. Okay. When they're and also they may be they may actually join in on the mortgage as an obligor. Okay. So there are three ways of dealing with this: as a guarantor, as a surety, or as an obligor. Okay. Where they join in as an obligor, and in the event of a default or some other breach of the contract, and the financial institution, the lender, has to go to realize its security, it can sell that property that was pledged as to satisfy the collateral, as well as it could go after the property that it mortgaged. Okay, because under this agreement, there are two properties: the one that the client is borrowing to get, and the second one that is being pledged to satisfy the down payment or the equity requirement. Okay, so the bank where the person who is pledging the property as equity or contribution, the bank can go after that property as well as the mortgage property. And then at the end of the day, if there's insufficient funds, they can go after that person as well as the borrower. Okay. Similarly with the guarantee, because they have signed as a guarantor, you can go after them as guarantor, and you can go after the property because the property has been used to support their guarantee. Okay. Now, with regards to the surety, the surety normally is not an obligor or a guarantor, and so the bank, so you as the lender can only go after the asset that was pledged, but you can't go after the surety. Okay, the person who pledged the surety. So you can't go after any other assets that they own. So you were limited only to that property that they pledged. Okay, but if they pledge as a guarantor or they pledge as an obligor to the mortgage, you can go after them in their personal capacity and look at any other assets they may have. Okay, and hence you'll see the reason when we come to that, I think on the next screen, the advice for them to get independent legal advice. Okay, and then I think it is on the next screen. So if the primary borrower defaults and the bank commences proceedings for possession and exercise of the power of sale, the guarantor may allege that there was some undue influence, either wielded by the primary borrower over the guarantor or the bank itself. Okay, so in the case of, let's say, the child coming to the bank to borrow, okay, and and the parent is pledging the property, okay, the parent could probably say, well, the child forced me to do that because I live with them and I depend on them. I don't work. And so I depend on them. And so I was forced, based on that, I was forced to, I felt forced to pledge my other property. Okay. So, so because of this risk of undue influence being charged in, by the person who's pledged, okay, this is where the other point comes in. To mitigate the risk of undue influence by the bank and by borrowers, the guidelines in the case of Barclays Bank, etc., et al., okay, are instructive to banks with regard to advising the surety or the guarantor or obligor to seek independent legal advice before agreeing to act as surety or guarantor or obligor, and/or distinguishing relationships which may have undue influence existent and acting accordingly. Okay, so basically what it is saying is that this case, this 1997 case, outlines some guidelines, primarily of which the banks were advised to have people who are pledging properties in these types of instances to seek independent legal advice. So if they have their own attorney, they can go to their own attorney and get independent legal advice. And proof of this, banks will require a letter from that person's attorney, stating that they have been consulted by that person and they've been advised of the risks and the liabilities associated with pledging their property either as surety or guarantee or by obligor. Okay, and in addition to that, banks have their own standard forms that they will give to the surety, the guarantor, or the obligor. They would give to them and to take to their attorney. Okay, and have their attorney execute also on the bank's form. Okay, but that would be forwarded to the bank, still under cover of letter, under which the lawyer will reiterate that they have advised and counseled the client, blah, 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 and we attach your form. We also attach your form of independent legal advice. And those forms are, in most cases, called, the form is normally called independent legal advice forms. Okay. Any questions on that? Excuse me.
I have a question, Mr.
Sure.
Nottage. In that similar example, I guess it would be the reverse. So if my parents, for example, have an existing mortgage, and I'm now coming up being a young professional, let's say there was a fire in the home, and so repairs have to be done on the property, on the house. And so now they need additional funds from the bank in order to carry out those repairs. And so they asked me to assist them and get them that additional funds. And so I'm now, I guess, a guarantor to the mortgage, to their mortgage.
Right.
And is there some way that I can get out of that now, like some years later, now that I want to get my own mortgage? Yeah, that's it. Is there some way that I can now get out of that?
Yes.
Let's
Yes.
say that I I did at that time sign the legal advice, independent legal advice and all of that. That was at, let's say, 10 years ago. But now, 10 years later, I now want to create my own credit, get my own mortgage, and I've already, I guess, helped them as far as I can. How can I now get out of that?
Yes, you can approach the financial institution, because remember now, depending on the length, the length of the mortgage, uh, the length of the mortgage term, uh, the first 3 to 5 years is primarily interest. But after that, you begin to see more and more money being applied to the principal. So within a period of, let's say, 10 years, the amount of principal that may have been extinguished or paid back may be equal to or greater than the amount that was required for down payment. Okay, so let's say the amount that was required for down payment was $15,000. Okay, and now some $20,000 in principal have been paid down. You can apply to the bank, and they should release. Now, if they feel that your property is more important, more valuable or more disposable than the property mortgaged by the parents, they may be reluctant to do so. But then, of course, you can also you can then it may if going higher up the chain in the financial institution doesn't produce any results, then you may have to engage an attorney who would write them. And under that threat, the bank may say, okay, we would release. But generally speaking, where the property has been pledged to satisfy an equity requirement. Once that equity level has been reached, the person pledging that property can ask for it to be released. Okay.
That's fine. Does it also apply if it wasn't property, but if it was more security, like a salary deduction?
Well, now salary deduction is not security. Salary deduction is just a method of payment. Okay, you have three major bases, three key factors, I should say, three key factors on which loans are granted. Okay, the first being character, the person's character. Okay, that is this person's propensity to pay. The second is their ability or their capacity. Okay, are they able to pay? And then the third is the collateral. Okay, what if they cannot pay? Okay, so there are three key factors. There's the character, the capacity, and the collateral. Those three key factors. Okay, and so salary deduction is not is in none of them. Okay, it is not collateral. Okay, but actually it is the ability, I should say.
It's
It's
right.
not ability, sorry, or capacity. Okay, so it definitely isn't collateral. So it's incapacity. Okay, so a lot of people say, well, the security for this loan is my salary deduction. No, that's the security to the bank that the loan will be paid. But it's not collateral security. It is not like a chattel mortgage over a vehicle, or a debenture over the assets of a business, the stock and trade, or a mortgage over a developed or undeveloped property. So very, very rarely you'll find banks will release a person from the salary deduction.
Okay.
All right.
But if I had, let's say I have registered stock with the central bank, and so I use that to pledge that as some sort of collateral that can be released.
Yes. Again, once the principal balance has reduced to an amount equal to or greater than it, there should be no reason for it to be not being released. Okay. Now, something that you might be able to argue. Something that you might be able to argue, going back to the salary deduction, right? As a borrower, you may be able to argue, or as a lender, you may be able to consider. Okay. Excuse me. Excuse me. Where there's a life insurance policy and there's sufficient cash surrender values in it, okay, that is greater than or equal to or greater than, well, I would say greater than, because you have to factor in there's a principal balance and there's also accrued interest. So where the cash surrender value or cash values in the life insurance policy is greater than the payoff amount, as a lender, I may consider releasing the salary deduction. And the reason for that is if the person doesn't pay, because I, excuse me, oh boy, because I, as the lender, I have an assignment over that life insurance policy. I could claim against those. I could call the life insurance policy and say to the life insurance company, you know, we have an assignment over this policy. The client is in default. We want you to pay us the cash, the cash values in this policy. Now, some policies, the only way of doing that is to cancel the life policy, and that'll be a risk that the borrower would take. You see, but if I was a borrower and I had a policy that allows me to take out my cash values and probably reduce the principal sum. So let's say, for example, let's say I owe $10,000. I owe $10,000 on my mortgage, and I have $15,000 worth of cash values in my life insurance policy. And it is a life policy where I can take out my cash values, but it will reduce my face value. So let's say the face value of that is $200,000. Okay. So rather than me now having, after I've taken out that 10,000, rather than me having a policy value of $200,000, I would now have a policy of $190,000. So upon my death, my beneficiaries will not receive $200,000, but they will receive $190,000. Okay, which isn't bad because it means while you're alive, you benefited.
Reasonable. At least you get some benefit of your insurance while you're alive.
While you're alive, yes. Okay, so if you sometimes people who come to me for financial advice, because I am a financial planner as well. So when people come to me for financial advice, if they have more than sufficient, if they need to take out cash values and it does not extinguish the life policy, I recommend that they take it out and use it for the purpose that they need, because it might be a medical emergency. Okay, and so they need access to those funds. You know, especially in this day and age with COVID. You know, and based on a person's age, $190,000 may be sufficient. That if they die and they are still the breadwinner in the family, if they die, the $190,000 may be sufficient to take care of the surviving spouse or whoever the beneficiary is. You know, so you know, it might be, you know, or take care of the children until they reach the age of majority. You know, they turn 18. But there are ways that we as lenders can work with our clients, and then and there's also on the other side, if you find yourself as a borrower, there are some of these things that you can do to release your property earlier, or you know, or release it altogether from an obligation. I hope that helps.
Yes, it did. Thank you.
All right. Okay. So let's look at the second one, mistake. Okay. All right. A mistake will not affect the validity of the banker-customer contract unless there is a serious mistake of fact. A mistake may be made as to the subject matter of the contract, the signing of written documents, for example, checks, and the identity of the parties. Where a mistake is proven to have occurred, the contract is considered void. In order for a bank to recover money paid by mistake, certain conditions must be satisfied. And we're going to look at them in this next. Okay. So the first, the first of three conditions that must be satisfied is where the bank pays a customer's money to another person under a mistake of fact, having believed the signature was genuine when it was in fact forged, or having believed that a payment had not been stopped, that is, a stop payment had not been put in the check, when in fact it actually had. There's no requirement to prove that the bank was negligent in paying the amount, only that it had been mistaken in doing so. Okay. The second is the bank pays without the customer's consent or authority, particularly where there are insufficient funds, believing that there are sufficient funds to cover payment, or pays a stop check, believing no countermand is in place. Okay, so this is an instance where you may know a customer, and you say, yeah, there's insufficient funds, I'll pay it, and you're saying, I know this customer have funds on another account, and so you make that that mistake in paying out the paying out the funds. Okay, and it could be an instance where the printout that you looked at or whatever it is showed that there was sufficient funds on another account that you could transfer, whatever it is, but it just so happened that there was some glitch the night before and it didn't update. Okay, so things happen. And thirdly, the bank pays a check and later attempts to recover the funds, but does not act with great speed. Okay, so this is where the bank takes too long to act. Okay, and that case is Cox versus Masterman, if you're interested in looking at that. For those of you who are in an operations side dealing with checking accounts. Okay. However, a bank may not be able to recover funds where it made a representation to the payee that it was making the payment, and the payee changed his position in good faith and to his detriment as a result of receiving payment, or it paid another bank as a collecting agent for the payee, and the payee has withdrawn the funds. Okay, and this is why it's so careful, so important sometimes that you may have to put a hold on funds when you're doing something, okay, or when you make a promise to a client, because sometimes people do weird things, customers do weird things. The paying bank can only collect from the payee, not the collecting bank. However, the collecting bank must have no notice of mistake before the funds are withdrawn and have acted in good faith. Where the paying bank is unable to succeed in recovering the paid funds due to a mistake of fact, it may be able to exercise and enforce its proprietary right to trace the funds. A customer is also entitled to reclaim monies paid under a mistake of fact. Okay, and again, a lot of this has to do more with on the operations side, relating to checking accounts, not mortgages or loan facilities, except where that checking account may have a overdraft attached to it, overdraft facility attached to it. So then it may come under the lending side of things. And finally, under mistake, where a bank has mistakenly credited a customer's account, it may redebit the account or reclaim any funds which the customer has withdrawn from the account. However, the bank may be a stop that is prevented from recovering the funds if the customer changes his position in good faith as a result of the credits mistakenly made by the bank. And there's a case in point there, Lloyd's Bank. Actually, there are two cases there, Lloyd's Bank and United Overseas Bank. Okay, so again, that is primarily for those persons who are on the deposit side of things. And then thirdly, misrepresentation. Misrepresentation is a false statement of material fact made by a party to a contract or his agent, which induces the other party to enter into the contract. The parties to the banker-customer contract may rescind the contract where any of the foregoing types of misrepresentation exists, and damages are available for fraudulent misrepresentation under the tort of deceit. Three types of misrepresentation are innocent misrepresentation, negligent misrepresentation, and fraudulent misrepresentation. Okay, innocent misrepresentation is a false statement made by a person who had reasonable grounds to believe that it was true when he made the statement, and at the time when the contract was made, Negligent misrepresentation is a false statement by a person who had no reasonable grounds for believing the statement to be true. And then fraudulent misrepresentation is a false statement by a person who knew it to be false, or who believed it to be false, or who recklessly did not care whether it was true or false. Okay, so there are some slight differences between negligent and fraudulent misrepresentation. Okay, and then we have negligence. Negligence is a tort where there is omission to do something which one has a duty of care or obligation to do, but fails to do. In order to prove negligence, the defendant must have owed a duty of care to the plaintiff. The defendant must have breached that duty to the standard of a reasonable man, and the plaintiff must have suffered some loss or damage as a result of the defendant's breach of duty. Banks must be careful to avoid negligence by ensuring that they do not make negligent misstatements. That is, where there's a special relationship between the parties and one of the parties relied on the particular skill of the other party and therefore suffered some loss, and that other party knew of this reliance. And two, by avoiding professional negligence, that is, giving financial advice or information to a third party. Okay, so there are two cases where, or instances where the bank must be careful to avoid negligence. Sorry, any questions on that before we, or anything previously before we go further? I want to end Module 6 by looking at the Homeowners Protection Act. I might go through it fairly quickly so as to start Module 7. So these are 12 areas that we'll be looking at under the Homeowners Protection Act. Some which we covered in Module 5. So you'll see them come up again. But we have to be aware of these various sections. So the first is the obligation to give notice prior to exercising the power of sale, and that is found in sections 4 and 7. Sections 4 relates to instituting court proceedings, and section 7 relates to exercising non-judicial power of sale. So the mortgagee must give a 30-day notice in writing prior to either instituting court proceedings or exercising non-judicial power of sale. In the case of court-instituted proceedings, the court may, as it sees fit upon ex parte application by a mortgagee, vary the method of service of the notice on the mortgagor. And we discussed that last class. Here's one that we didn't cover: the duty of fair dealing. In the exercise of the power of sale, the mortgagee must not engage in unfair, deceptive, or abusive acts or practices. And it is interesting that this is not clarified. That is, what is meant by unfair, deceptive, or abusive acts or practices. Okay, and in this act. It'll be interesting if a case comes before the courts, how that would be dealt with. But it says, in the exercise of the power of sale, the mortgagee must not engage in unfair, deceptive, or abusive acts or practices. Conditions on the exercise of power of sale. Again, we've looked at this in Module 5, where a mortgagor has failed to secure a sale of the mortgage property at market value within 6 months of either issuing a notice of default or having obtained vacant possession. The mortgagee at his option may serve notice that it intends on accepting the highest qualifying bid offered in writing. The notice must include that the property may be sold at less than the market value, and that the mortgagee may pursue the mortgagor where there's a residual debt after the sale. However, and I alluded to this earlier, the mortgagee may be barred or prohibited from pursuing the mortgagor where there's a shortfall in sale proceeds if at the date of the sale, either a sum equal to, and this is one of our parking lot issues at the beginning of class, either a sum equal to or at least 1/2 of the principal and accrued interest has been paid to the mortgagor, or the mortgagor has been in occupation of the dwelling house for a period of not less than 50% of the original mortgage term. And last class I explained, let's say, for example, if the original term of the mortgage if the original term of the mortgage is 20 years and the client has been in the house, say 10 or 11 years, you as the mortgagor, if there's a shortfall, can't go after the mortgagor. Okay. Within 10 days of receipt of the mortgagor's notice, the mortgagee's notice, the mortgagor has the right to issue a notice of objection, stating his, her, or their intention to either pay the amount of principal and interest at a specified time, or to remedy any default consisting of any breach of any obligation arising under the mortgage, or to apply to the courts for relief. Should the mortgagor fail to issue a notice of objection, the mortgagee may make the required, take the required steps to sell the mortgaged property. The provisions of this section, and please note this, and this is in bold, the provisions of this section apply to all mortgages, notwithstanding any provision in any other law or custom, or any, excuse me, or any clause contained in any mortgage document executed either before or after the coming into effect of this act. Okay, so this applies to all mortgages, whether they were executed before or after the coming into effect of this act, or whether or not any action was taken prior to or before the coming into effect of this act. So some serious implications for us as lenders. Okay.
So, Mr.
The
Nottage, on
mortgagee
that
shall not
point,
sell the mortgage.
on the point of the notice, is there a particular form?
Yes, it's the act. Let me just get the act here. Okay, section 11. Okay. Okay, section 11, subsection 2. Okay, so section 11, subsection 2 says a mortgagee shall disclose in a notice issued under subsection 1, okay, that A, in exercising his power of sale, the mortgage property may be sold. B, subject to subsection 8, that blah, 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 blah. Okay, so, and it says within 10 days of receipt of the notice referred to in subsection 1, the mortgagor may issue a notice of objection. And that notice of objection has to be specify certain things. Okay, so there's three options. So it is a a standard form. There's some things that have to be included in that notice. Okay.
Yes, I see it.
Okay. Alrighty. So now and again we touched on this last class. The mortgagee shall not sell the mortgage property to any of the following parties: a director or employee of the financial institution, an immediate family member or a director or employee of the financial institution, a company beneficially owned by a director or employee of the financial institution, excuse me, any person who by the nature of their intimate relationship with a director or employee of the financial institution would be given a more favorable consideration as a result of that relationship. Okay, so then of course when the bank is conveying to the when the bank is conveying to the purchaser, there are some things that must be where the power of sale has been exercised. There's some things that have to be included. So it says the conveyance from the mortgagee to a purchaser pursuant to the exercise of the power of sale must contain a clause reciting the mortgage document. Okay, that is the mortgage document of the property being sold, and that the mortgagee has exercised his right to sell after giving more notice to the mortgagor. The effect of the above recital is to bar all equity of redemption of the mortgagor or his successors in and to the mortgaged property. Okay, so the importance of doing the above is to protect the lenders, the mortgagees. Okay, because you don't want the mortgagor coming back at some later time, or his successors coming back at some later time. Okay. The exemption from stamp duty. The mortgagee shall be exempt from paying 50% of any sum due and owing under the Stamp Act, Chapter 370 of the sale of a mortgaged property in instances where the mortgagee sells the property under power of sale within 5 years on the date on which the last advance was made by the mortgagee. So there's a very small window there. So that relates to where mortgages have gone into default fairly early in the game, because you see it's 5 years from the date of the last advance. Okay. The mortgagor's request for mortgage statement, again, we talked about this. The mortgagee must respond to a mortgagor's written request for a statement of account within 30 days of receipt of that request. The mortgagee must supply the said statement free of charge up to twice in any calendar year. If the mortgagee fails to respond without having a reasonable excuse, any rights that it may have for the enforcement of the debt will be suspended until it has complied with the request. And please note that this section about the responding to the written request within 30 days and supplying up to twice free of charge in the calendar year relates only to those proceedings initiated after the coming into effect of this act. Okay, so it may be a mortgage that was granted before, but the proceedings cannot be before the coming into the effect of the act. It has to be proceedings that were initiated after the coming into effect of the act. Okay. Yes, ma'am.
On proceedings, so requesting of and receiving the statements, free statements twice per year only relates to those accounts that are being repossessed, or it relates to all mortgage accounts. What do they mean by proceedings?
Okay, all righty. You weren't very clear, but there's some dragging and lagging, so it almost sounds like your words are being stretched. But let me just go back to the last point on that last slide. This relates only to those proceedings initiated after the coming into effect of this act. Okay, so in answer to that question, yes, the statement of account twice a year, responding to the customers on a mortgagor's written request within 30 days. Okay. Okay, and them receiving it free of charge up to twice in any calendar year. Because you'll see in the second point it says if the mortgagee fails to respond without having a reasonable excuse, any rights that it may have for the enforcement of the debt will be suspended until it has complied with the request. Okay, so again, only those initiated, only those with proceedings and proceedings initiated after the coming into effect of this act. So that is important.
So does that mean that this only applies to those accounts that are now, I guess, getting ready for repossession? So if I have an active mortgage account and I am actively paying for it, this does not apply to me?
No, it doesn't. No, it doesn't apply in that instance. No. Only in instances where the bank has exercised its power of sale, and there are legal proceedings going on after March 2017, and those proceedings were initiated after March 2017.
Okay, thank you.
Okay. So the mortgagor's request to transfer a mortgage, where a mortgagor exercises his entitlement under Section 17 of the Conveyancing and Law of Property Act, Chapter 138, the mortgagee must assign or convey the debt to the new lender without requiring the mortgagor or the new lender to pay any costs associated with that transfer. Okay. And then Section 18, this is where the mortgagee transfers or assigns or sells the mortgage loan account. Okay, not the mortgaged property, but the mortgage loan. Okay, the loan account. If a mortgagee transfers, assigns, or sells the mortgagor's debt, the mortgagee must advise the mortgagor in writing not less than 30 days before the effective date of the transfer, assignment, or sale. And that's in subsection 1. Subsection 2 says that the notice must be served on the mortgagor either personally or by registered post. Okay. Then we have, which we mentioned at the beginning, so I'll reiterate them, statutory offenses and penalties that apply to breaches of any of the sections of this act. The statutory offenses and penalties, as outlined in Section 20, says a financial institution that contravenes or fails to comply with any provision of this act commits an offense and is liable to pay a fine not exceeding $200,000. Similarly, a director of the company who knowingly concurs in a contravention or failure to comply with any of the provisions of the act commits an offense and is liable to pay a fine not exceeding $100,000. Okay. So in addition to the statutory offenses and penalties, there are administrative fines by the regulatory body. And in most instances, this would be the Central Bahamas. Notwithstanding any penalties that may be imposed under Section 20, a financial institution that contravenes or fails to comply with any provision of this act may be subject to an administrative fine of not exceeding $200,000. And similarly, a director may be subject to an administrative fine not exceeding $100,000. So we can see that the financial institution itself faces the possibility of a fine of up to $400,000 because they're statutory offenses and they're administrative offenses. And then the director, they'll have to pay. Normally, the director doesn't pay this out of their pocket. This comes from the financial institution. So again, $100 under statutory offenses and $100,000 up to $100,000 under the administrative fines by the regulatory body. So we see that in total, a financial institution may find itself paying up to $600,000 in penalties. Okay. And it could be more if it's more than one director. Okay. So if it's more than one director, each director would be fined $100,000 under Section 21 and Section 20. So some serious stuff. Okay, judgment dates and expiry dates. And this will bring our thing to an end. Previously, judgments granted by the court with respect to mortgages were not subject to an expiry date. However, with the coming into effect of the Act, mortgagees are statute barred from recovering any sum owing under such judgments after either the expiry of 6 years from the date on which the judgment was obtained, or the date, the last payment, or I should say the date of the last payment pursuant to that judgment. Okay, so what this means is that if judgment was obtained on a certain date and no payments were received subsequent to that judgment, then the judgment expires on the 6th year. Okay. B means that if judgment was obtained at a certain point in time, but let's say subsequent to that judgment, a payment was made, well, then the judgment will expire 6 years from the date of that last payment. Okay. And that ends that. I want to quickly, I want to start chapter 7 in our remaining time. So let me switch over. Okay. Okay, let's. All right, what do you got here? What do you got here? Hello, can you hear me?
Yes.
Okay. I'm having difficulty bringing up that.
It's not my last
Yeah.
question is.
Pardon?
I have one last question on module 6.
Okay.
With respect to transfer of mortgage, section 17,
Okay.
it says where the mortgagor exercises his entitlement under section 17 of the Conveyancing and All Property Act Mortgagee must assign or convey the debt to the new lender without requiring the mortgagor or the new lender to pay any costs associated therein. So what does this mean exactly? If I have a loan at Scotiabank and Fidelity has a reasonable rate that I'm interested in, and I want to switch my mortgage over to them, would that mean that my mortgage at Scotia is transferred to Fidelity, that actual document?
Yes,
Or
I,
does it mean that the loan will be satisfied, meaning that the mortgage document, the mortgage will be satisfied and I will get a satisfaction on that document and then I have a new mortgage? Or do I create
No.
a transfer of mortgage document?
the latter, there will be a transfer of mortgage document. There'll be a transfer of mortgage document from Scotia to Fidelity in the case that you've mentioned, and it should be at no cost to yourself.
So there will be no stamp duty, VAT, or recording fee applicable.
No, not under this act. Okay. Can you all see the PowerPoint presentation?
No, no, sir.
No. Oh boy. Yeah. Okay, let's see. Okay.
That's a sign, Mr. Nordich.
Pardon?
That's a sign.
As a sign?
Mm-hmm.
Okay. Can you see it now?
Oh man, it's up.
Yes.
I'm trying to make up time for that the class we had missed. So I'm going to go through this fairly quickly. Okay. So alrighty. So understanding the mortgage process. If I can get this moving. Yes. Okay. So the overview, basically, you have the application, the assessment, the decision whether it's a yes or no, the acceptance of the yes by the applicant, the engagement of the attorney, the completion of the legal work. Once the legal work is completed, back in the office, compliance with the approved terms and conditions of the mortgage. Then you look at booking the loan, and then once that loan has been fully repaid and it comes to the end of its term, you look at discharging the mortgage or a satisfaction of the mortgage. So just looking quickly at the mortgage process. So this consists of 4 key functional areas or pillars. Effective working in tandem to achieve overall profitability and sustainability of the bank. These pillars are loan origination, which is the branches, loan underwriting, which is the credit underwriting or your decision-making body or department, loan administration, which is that department that actually books the loans and handles all the collateral security. Then you have your loan servicing department. This is the people who you get engaged should things go wrong. That is your collections or your asset management or asset recovery department. Okay, so let's look at this diagrammatically. Okay, so origination or our branches, it's sales oriented. This is where you have the initial client contact. You deal with your customer issues up front. You complete and submit the credit application. This is where you do some client servicing, make sure that the loan conditions are met so you can close the loan. So from the origination department, once that loan is ready for submission, it goes to the credit underwriting department, and they are concerned with risk management and control. So their sub-portfolios are credit risk management, risk control, market risk assessment, and credit adjudication. Adjudication comes from the word judge or judicial, which means to make a decision or to judge. Okay. So once credit underwriting, and you see an arrow going back and forth, because sometimes the completed application, credit underwriting may say, hey, you need to correct this or add this or whatever it is. And so they give you an opportunity to make the correction or make the addition. Then you go back to credit underwriting. Here it is now with your recommendation. And so credit underwriting say, okay, it's a yes. If it's a no, well, then we don't go anywhere. You just go back to your client and let your client know that the application was not approved. And then you do some other things, like, try to give the customer some other roadmap to achieving their goals. But that's a different subject for different course. If it's a yes, you send it to from credit underwriting. It goes to credit administration or loans administration, and the overarching responsibility is operational risk and process control. So they deal with credit disbursement and collateral adequacy, making sure that they have the right collateral and also the other conditions of the loan are met. And they're also concerned with the input and output. So inputting the loans and getting any checks out. As you can see, that there's a two-way arrow between them and the branches, origination, because sometimes the stuff that they need to get from the branches. Sometimes they have questions, so there's a back and forth. If things go wrong, you call in your credit busters, who are your loan servicing department. They're concerned with risk control. They either stabilize the credit or repair it. If not, we call it the carrot. So credit stabilization or repair is where you offer the carrot. Recovery is where you offer the stick. Okay, so you may have to get out your licking stick, and that's where repossession comes in, sale under your power sale, your power sale clause, et cetera, et cetera. If the account is able to be stabilized or repaired, it may be returned to the branches, and after a certain period of time, when the customer's credit history is deemed to be repaired, you may again begin the new process of giving them an additional loan. If you've gone to recovery, credit underwriting does not want to see that customer again. Okay, so what I've done a chart here, which you can look at your leisure. Okay, so the steps in the mortgage process: the initial interview. The second point, the borrower finds the property, executes the agreement for sale, obtains the appraisal. They come back to you again. Now, in that first initial interview, they do like a pre-qualify, and you give them you outline the necessary items they require. Okay, in the second interview, you gather some information, and then you get the complete picture, and you complete the application with them. The fourth step is the credit assessment and processing, verification, structuring the loan. That is like, whether it's the interest rate and the term of the mortgage, et cetera, et cetera. Document the terms, what else you need, life insurance, et cetera, et cetera. Recommendation and submission. So at that point is where the branch makes a recommendation and submits. In fact, let me just go to that screen one time. Okay, so you see the branch is involved in step one. The borrower, step 2, branch in step 3, the branch in step 4. They send it to credit underwriting, step 5. Credit underwriting reviews the completed application. If there are any additional conditions they feel should be added to mitigate against any risk, or they feel it may have been left out, they will ask you to put those in, and then they make a decision whether it's yes or no. Then we see to the branch, step number 6, the branch is involved in advising the client of the decision. 7, the commitment letter is issued and hopefully accepted by the client. So if that happens, the instructions are given to the attorney. So normally the issuance and acceptance is done by the branch, and the instructions to the attorney, if you have a centralized loan administration department, they normally will send out the instructions to the attorney. Number 8 is dealt with by the attorney, and that's where the attorney will review your instructions or the instructions received by you on behalf of your client. They begin and complete their work, which involve reviewing title documents, doing title and cause list searches, preparing documents for the borrower's execution, completing an opinion of title, and of course, preparing a cover letter so they could send that whole package to you. Either the branch or the credit administration department, the originators or the administrators may receive that package. So upon receiving that, they'll examine it, the letter, making sure that also there's the opinion on title is included. There's a list of title documents and a copy of any executed document. So if there's a conveyance that is necessary because a property was purchased, a copy of that, and a copy of the mortgage document. Also in there, you would want to have a copy of the registry receipt, evidencing that the lawyer has lodged the documents well, that'll come later, for recording. So 10, compliance with approval terms and conditions. 11, documenting that compliance, booking the facility, monitoring and controlling, managing non-compliance, managing delinquency, reviewing, and then finally, satisfying the repaid mortgage. Okay, that chart is at the end of your module 7. Okay, what you'll find is that going back to step number 1, where you outline, you pre-qualify the client and outline the necessary items. Sometimes you may provide this kind of information in some format to the client. So you'll have your general required items. So the first thing is you need income verification, which if the person is if the person is employed, you need employment letter and recent pay slip or recent, if they are self-employed, have their own business, you need a minimum of 3 years financial statements and corresponding years bank statements. The second thing you need is printout of any loans they have with other financial institutions. Thirdly, most recent credit card statements if they don't have any credit cards with your institution. And fourthly, they need ID, whether that's passport, voter's card, or any other form of ID that your financial institution requires. And then also not to be left out are some items related to the type of lot, and also we'll see in a few minutes relating to appraisers and attorneys. So if it's a vacant lot, you need an appraisal, you need agreement for sale, you need evidence of the deposit paid, and evidence of subdivision approval if it's a excuse me, if it's a new subdivision. If it's a developed lot, you need appraisal, you need agreement for sale, you need evidence of deposit paid again, And if it's a new subdivision, you need evidence of subdivision approval from the Ministry of Works. If it's a construction mortgage, you need the appraisal, you need the agreement for sale, you need the title documents if the property is already owned by the borrower. You need the evidence of deposit paid. For example, if it's a lot and building package, let's say they go to, they go to some construction development company who offers lot and building packages, and they've come to you for financing. Evidence of subdivision approval if it's new. Okay. Approval of building plans and specifications, 3 construction estimates, and the construction contract. Okay. Construction loans. Excuse me. What it must be borne in mind with the construction loans. Construction loans are drawn down in stages, and they're like 5 or more stages, depending on whether it's single story or 2-story or split level, whatever it is. Okay, and during the construction stage, contractors' all risk insurance is held to cover any liability in case something happens to the building during construction. It is stage payments are involved. That is, the stage payments are released against the inspection report or the Ministry of Works report. And during construction, interest-only payments are paid by the client to yourself. Okay. On the final stage payment, that is released against the final inspection report and receipt of occupancy certificate. So you need to have the occupancy certificate in order to release the final stage. At that time, any accrued interest is paid. The loan is converted to a fully amortized loan, and the first payment is due within 30 days. Full perils insurance coverage is held at that time. So the contractor's all risk insurance that you took initially, that falls away, and full perils insurance takes place, including hurricane coverage. Then you hold some retention monies, which are normally 5% for a specified period. This may be for 30 days or longer, depending again on the extent of the, how the size of the contract, but normally it's for 30 days. Okay, and then discharging the mortgage. Once the mortgagor has paid all sums that are due and owing under the mortgage, the lending institution may at any time thereafter reconvey or reassign the mortgage premises to the mortgagor or as the mortgagor directs. The most common form of discharging a mortgage is via a satisfaction of mortgage. And then it gives you the definition. A satisfaction of mortgage is a document generated and signed by a mortgage lender acknowledging that the borrower has paid off the mortgage loan in full and that the mortgage is not and that there's no more mortgage over the property. Okay, and that pretty much ends that. And then the rest of this is just basically easy reading, because it talks about title search, root of title, cause list, opinions of title. So it'll just tell you about what title is, the title search, establishing a good root of title, the cause list, explaining the cause list. Okay. And it just says like there are generally 2 types of cause lists, the daily cause list and the weekly cause lists. And some courts also have supplementary lists. Okay. The daily cause list is a list of cases to be heard by the courts on a given day, hence daily cause list. The weekly cause list consists of cases to be heard by the courts within a given week. And then a supplementary list consists of cases, mostly urgent cases, that may have been missed from the daily cause list, again, because the weekly cause list would have already, or the daily cause list may have already been issued, and because of the emergency a supplementary list had to be generated. Okay. And again, easy reading, the opinion on title, talking about the interest rate, fixed rate versus adjustable rate mortgages, and ending with what the prime rate is and who sets this rate. So the prime lending rate currently is 4.25%, and that's set by the Central Bank of the Bahamas. And there ends module number 7. All righty. If you have any questions on any of those 2 models or modules or any of the 3 that we've covered, give me a shout, send me an email, and I'll respond usually within 24 hours or less. Okay, so thank you very much for giving me the extra time tonight to start and complete module 7. And so next week you will, and the following week, you will be with Mrs. Archer, and then I'll see you again December the 1st.
Have a good night, Mr. Nottage.
All right.
Have a
Thank
good
you,
night, folks.
Mr. Nottage.
Thank you.